streaming on Facebook this afternoon. Important to mention that this session in particular is eligible for nutrient management continuing ed credits. So if you need nutrient management continuing education credits, please go ahead and type your name and your voucher number in the chat. We're going to need you to do that at the beginning and at the end. And Marta, our coordinator, is typing in a reminder right now in the chat. So she'll type another reminder towards the end to remind everybody to do that. And I also want to let everyone know to type questions in the chat throughout today's webinar. We will be hearing from our two presenters first, and then we'll be having time to address questions. So go ahead, feel free to type questions as we go, and we'll hopefully, time permitting, be able to address them all at the end. Want to go ahead and introduce our speakers. I'm very thankful that they're here to join us today. We've got John Mueller, Vice President of Litigation for the Chesapeake Bay Foundation. And we've got Bobby Whitescarver. Bobby is a farmer, former NRCS employee. Bobby, you've got a lot of titles. I'll stop there. We do have longer bios for the speakers of today's session and all of our sessions available on the ALEI website. And with that, I will hand it over to John, who I think is kicking things off for us. So thanks, John.
Thank you, Sarah. I've got a presentation here, so if we hang on for a sec. Oh, not working. Hang on here a sec. There we go. It worked fine before. I don't know why it's not working now, Sarah.
That's looking good. If you just want to go ahead and put that in presenter mode.
Okay, great. There it goes. Wasn't showing up for me. All right. Again, good afternoon, everyone, and thanks for the opportunity to talk to you about what we think is a really important case, and so glad to have Bobby along with us here. He and his wife Jean are fantastic Bay supporters and have done tremendous things on their farm, and talk to you about that. So I'm just going to kind of go through the background here of how we got to where we are and where we are today as far as the litigation is concerned, and Bobby's with why he's joined us. So to kind of understand this, we always use this lingo, a TMDL, and it's not clear that unless you're a Clean Water Act aficionado that you understand what a TMDL is. So a little background on the Clean Water Act and the Bay TMDL itself, some information about the final phase 3 watershed implementation plans for New York and Pennsylvania. And then a little discussion about the enforceability of the Bay TMDL, why this TMDL is different than others that we might see around the nation. So back in 1972, Congress enacted and President Nixon signed, although it was with a veto override, the Clean Water Act in 1972 that kind of put things into play as far as the TMDL sections of the Act. But always I teach my students at Maryland that you kind of need to start with the purpose of the Act. So the rest of the statutory provisions are interpreted subject to this purpose. And here the main objective is to restore and maintain the chemical, physical, and biological integrity of the nation's waters. And that certainly includes the Chesapeake Bay. So under the Act, states are required to set water quality standards. Do they want the water body to be able to support fishing, shellfish, swimming, that sort of thing? They need to annually assess those water bodies and provide updates to EPA about what the standards are and their assessments. And they have to identify those waters that are identified as impaired. They're not meeting those water quality standards set by the states. Section 303D of the Act also provides for what are the states supposed to do if the for those impaired bodies of water. And Congress said that they were supposed to develop total maximum daily loads. I'll talk about that in a second. By 1979. And a TMDL is basically a waste load allocation. So that's the amount of a pollutant that's coming from a particular point source, plus load allocations. Those are from non-point sources like runoff, stormwater runoff from agriculture or urban areas, plus a natural background. Because a lot of rivers and streams already have some certain natural levels of pollutant, let's say. And then a margin of safety, because even Congress recognized that science is not always perfect, and that there needs to be an error on side of making certain that the water quality standards are met. So when you total that all up, the TMDL sets a number that the states are supposed to meet to reduce the amount of pollution that will then allow that body of water to meet water quality standards. So we'll talk about what those pollutants are for the bay. They're nitrogen, phosphorus, and sediment. And we'll talk more about the bay TMDL specifics in a little bit. One of the biggest problems with the 303D TMDL section is that Congress said they were supposed to happen by 1979, and it didn't. And when that dragged on for years, environmental organizations began to sue EPA under this constructive submission theory, basically alleging that the states had submitted a blank sheet of paper to EPA because they haven't identified their impaired bodies of water or developed TMDLs for them. And so it was up to EPA to do that. And in 1984, we got the first decision out of the Seventh Circuit, Scott v. Hammond. And it kind of followed after that. There was the Kingman Park Civis Association case in DC, a couple of American Littoral Society, American Canoe Society suits against EPA in Delaware, Pennsylvania, West Virginia, some memorandum of agreement, like with Maryland, that the states were going to identify what their impaired bodies of water were, or develop TMDLs, or EPA was going to do it for them. And probably for the Bay anyway, the most important decision was the American Canoe versus EPA decision in 1998 in Virginia federal court, in which the court upheld a consent agreement between EPA and Virginia, saying that Virginia was going to identify all the different water bodies within the state that were impaired by a certain deadline. And if it didn't do that, then EPA was going to do it and develop the TMDLs as well. And as I hope everyone knows, a portion of the bay is in Virginia waters. And so a portion of the bay was identified by Virginia as one that was going to need to be identified as impaired, and a TMDL was going to have to be made for it. And May 2010 was the deadline for doing that. And so that goal wasn't achieved. We saw, you can see in the chart here on the left that the biggest problem in the bay is anoxia or hypoxia, low levels of dissolved oxygen that basically prevent organisms from living, mostly in the deep channels of the Chesapeake Bay. But you can see from this image that, as far back as August 2005 and on up into the 2000s, the late 2000s now, that we're having the same problem, low DO. And so as part of the watershed states' recognition of this problem with low dissolved oxygen in the main stem of the bay, they got together and said, well, we're going to beat this 2010 deadline, and we're going to work together and create voluntary efforts on how we're going to achieve that, meet that deadline, and get the bay off the impaired waters list. So they signed a number of voluntary agreements with EPA. The first in 1983. There was a congressionally ordered study to identify what the impairments were. No surprise, too much nitrogen, phosphorus, and sediment were causing the low dissolved oxygen and bad water clarity problems that were harming aquatic organisms in the bay. Then in 1987, they signed another agreement that said, well, we're going to reduce all these pollutants by, or most specifically nitrogen by and phosphorus by 40% from 1985 pollution levels by 40%. And to do that, they developed what are called tributary strategies. I call them TMDL light because they were voluntary. There were no real accountability, no consequences for failing to attain goals. And while it's true that some of the states actually started to pass laws, state laws, to try and reduce the amount of pollution that was coming into the bay from their respective jurisdictions, they were not successful. And then in 2000, final agreement said, yes, we got to make the 2010 deadline. We're committed to doing it. And one of the other things that was really important is that Congress added a new section to the Clean Water Act, or at least beefed up Section 117. And in the 2000 agreement, they identified the 2010 deadline as something that they needed to meet. And so 117G in the statute says that EPA shall ensure that management plans are developed and implementation is begun to achieve and maintain the nutrient reduction goals of the Bay Agreement. So that was the really important piece that we were talking about before, that you have to meet these, the nutrient goals on time. So Section 117 essentially incorporates the Bay Agreement. By 2007, the Bay Executive Council, which is made up of the governors and the administrator of EPA, recognized that they weren't going to make the 2010 deadline. They asked EPA to start developing a TMDL using kind of the tributary strategies and the modeling used to develop the pollution limitations in those strategies going forward in developing the TMDL. But we realized back in 2008, actually, that when EPA wasn't going to make these goals, that there needed to be some what we felt to be legal pressure to require this to happen. And so we joined with former State Senator Bernie Fowler, Secretary of Natural Resources Philo Murphy, former Governor Harry Hughes, and Anthony Williams, as well as Maryland Watermen's Association, Virginia Watermen's Association, and the Maryland Sport Fishing Association, and sued EPA in 2009. We were able to settle the case in which the EPA agreed that they would establish a TMDL by the end of 2010, that they would have what are called watershed implementation plans, which are different than what you see in kind of your typical TMDL strategy. And part of that would, those implementation plans and the TMDL would require reasonable assurance that the goals were going to be met. And this is essentially a guidance that EPA has been following for decades in development of prior TMDLs for much smaller watersheds, that the goals that they identify in their TMDLs are actually going to be met. And another unique aspect of the settlement agreement and then the TMDL is that EPA might exact consequences if the states fail to achieve those goals. Also in 2009, President Obama issued an executive order requiring the states to, requiring the federal agencies to come up with plans on how they were going to reduce pollution to the bay. And EPA was kind of the overseer of all those plans, and then they submitted a final plan to, to the president, explaining how they were going to get there. And so then in December 29th, 2010, the TMDL came out. it's pretty unique because it allocates pollution among 92 segments within the Bay, but it also has this accountability framework. And it's, you know, if you're interested in this, going and looking at, I believe it's chapter 7 of the Bay TMDL document itself, it explains what these accountability standards are and the goals that they expect the states to meet. And so that's watershed implementation plans over 3 phases. EPA is going to track progress over 2-year milestones that the states set for themselves. EPA was going to track and assess their compliance. There was a deadline for completion, meeting the TMDL goals by 2025. And there were federal consequences for failure. EPA could take a number of actions under the Clean Water Act to attain that goal, attain the 2025 deadline. And this is just a slide that EPA put together to explain to the states and all the different representatives of the states that were working on developing the TMDL, of how they were going to assess and track, and if it wasn't happening, that they were going to actually take action against the states for failure to achieve the goals on time. And that did happen in several cases, especially even in the phase 1 WIP. Pennsylvania was deficient in its WIP analysis, and EPA made it go back to the drawing board and write another one. They withdrew, I believe it was $3 million in grant funding until that was done. Shortly after the TMDL was put in place, the American Farm Bureau Federation and a number of other agricultural related groups and the Home Builders Association sued, challenging EPA's action. CBF joined along with the National Association of Clean Water Agencies and some other municipal wastewater agencies in defending the TMDL. We got a decision out of the Eastern District of Pennsylvania that upheld the TMDL. That was a appeal to the Third Circuit, and the Third Circuit said, yeah, the TMDL was legal. Reasonable assurance was a justified prerequisite for accepting the watershed implementation plans that the states were putting together, and that the agreement itself was an example of cooperative federalism where states and the federal government work together to achieve Clean Water Act goals. That was again challenged, and the Farm Bureau took that decision up to the Supreme Court for certiorari. It was denied in February of 2016, and so the Bay TMDL has been upheld by the Third Circuit's decision and the Middle District of Pennsylvania. So since that time, you know, how things been going, and you can see from this chart kind of a quick glance for at least 3 states here that some are behind. They're meeting their agricultural and urban runoff goals, some septic. And then they were to put together their final phase 3 WIPs just last year and submit them to EPA for, we say approval, they say they don't approve them, whether you say approval or acceptance, whatever. They were allowed to go forward on the basis of these watershed implementation plans that we believe are facially deficient. For example, New York State's phase 3 WIP is 1 million pounds short of its nitrogen goal. Pennsylvania's phase 3 WIP only meets 73% of the nitrogen goal and is over $300 million short in funding annually. So it can't even meet the 73% goal because it doesn't have the money or programs to get there. And EPA accepted those WIPs without imposing any of the consequences that it identified to the states back when the TMDL was first implemented. So recently, EPA has come out and said, well, TMDL is just a number. It's just an informational tool. The 2025 deadline's an aspirational goal. A bunch of other arguments. The one that I'm sorry to say I find a bit laughable is that they said, well, just read our brief in the Farm Bureau case, and that's evidence that we're right. I usually don't rely on briefs of parties. I rely on the decision by the court. And here we have great evidence that EPA told the states that this isn't your grandfather's TMDL, that basically saying this isn't supposed to be like all the other, 40-some thousand smaller TMDLs have been written across the United States. We believe Section 117G compels implementation, and EPA is the party that's supposed to ensure that that happens. And that reasonable insurance, that means you're actually going to attain those goals, is important. One of the other things that's really important here is that Section 117, requiring EPA to ensure management plans and implementation, incorporates the Bay TMDL, the Bay Agreement. And in 2014, the Bay Agreement basically said, we're going to adopt the Bay TMDL goals. So by doing that in 2014, they have adopted the Bay TMDL goals into the agreement, and therefore are enforceable under Section 117G. One of the other things that's really important to note is that the Third Circuit even kind of looked at this issue and said it defies common sense and experience that EPA wouldn't take action here, because the Bay is affected by 7 jurisdictions, and one jurisdiction can't address the problem by itself. So EPA has to intervene and take aggressive intervention, and held that it would be arbitrary for EPA to approve a WIP that could not be met. So we joined with several of the states and other groups, including Bobby and his wife, Jean, issued a notice of intent to sue to EPA back in May. On September 10th, we filed a complaint in DC District Court, along with Anne Arundel County and Maryland Watermen's Association. DC, Delaware, Maryland, and Virginia also filed their own complaints the same day. And now the United States is required to respond by November 20th. Our 2 cases are going to be consolidated. We've asked the court to do that. And now we're just discussing a briefing schedule. Like I said, November 20th is the date that we expect the United States to file a motion to dismiss. And then we have to decide what date we're going to respond by. So that's kind of where we are right now.
Thanks, John. Thank you for outlining all that, giving us all that background. It's really important. At this time, I want to turn it over to Bobby. We always like to have farmer presenters at our conference, and with Bobby, we have a farmer and an environmental expert. So we're getting a 2-for-1 here. So Bobby, I'll let you take it away and describe your role in this case and why it was important for you and your wife to become involved.
Okay, well, thank you. Can everybody hear me okay? Everybody okay? All right,
Yep.
Well, good afternoon. It's a beautiful day here in Swope where we live and farm. It's 72 degrees, sunshine. We're at the beginning of the South Fork of the Shenandoah River. And Jeannie and I joined this lawsuit because we feel like we have done a tremendous amount of conservation on the 3 farms that we operate on. And we feel very strongly that there should be equality of sacrifice in all 6 jurisdictions in the Bay Watershed. And I don't feel like that's happening, especially in Pennsylvania. In Virginia, we started a agricultural best management practice program in 1984. And farmers have been enrolling and participating in various best management practices to keep the nitrogen, phosphorus, and sediment out of our local streams and out of the bay. And I do have a few pictures to show you. Okay, so this is my wife Jeannie and our valiant dog Val, who's a great asset to the farm. He's worth 2 men anyway, and this is one of the herds that we operate on. We have 3 farms. We have the River Farm. We have a farm in Northern Swope, if you can believe that. And then we have recently bought a farm in Churchville, Virginia. But this is what we're trying to do in the headwater streams, is bring back this native fish. Of course, this is brook trout, and we know that if we can bring this fish back to our freshwater streams, then we have restored the watershed in that particular stream. And I took this picture several years ago, standing in a spot that looking downstream from a farm that had fenced off their cattle in 2001. And I'm looking downstream at a farm that has not fenced their cattle out of the Middle River. Just look at those banks, if you will. And I turned around in the same spot and took a picture upstream of the farm that just put up a fence to keep his cattle out of the Middle River. And I just want to show you that again. Look at the difference in the banks. And when you take a 1,000-pound cloven hooved animal that's going to climb up and down the banks, they're going to tear that bank up and deposit and dislodge a lot of sediment into the water, not to mention the manure and urine that's going in it when they have direct access to the water. Now, this is a drone shot of our river farm on Middle River. We fenced our cattle out of this farm in 2004. This drone shot was taken last year. We fenced off a half a mile of Middle River and 2 tributaries. And we did this with assistance from the state and from the federal government. They helped us put in watering systems. You can see my cursor there. That's a gravity-fed watering trough there. And we have 3 watering systems on this particular farm. And I wanted to share with you the results of some E. coli sampling that we've been doing. When the river enters our farm, up here at the top of the screen, the E. coli counts are consistently over 1,000 colony forming units per 100 milliliters of water. And when it leaves the farm, it's consistently 55% reduced in E. coli. And there's got to be a correlation between the amount of E. coli and the amount of nitrogen and phosphorus and sediment. I'll show you a few pictures of that. This is, now I've been sampling the river for 3 years, every month, and we compile the data for the Friends of the Middle River. This is just a picture of some of the Petri dishes. With cattle in the stream, you're going to get well over 1,000 colony forming units of E. coli. And without cattle, if we can fence them out, it's a lot less. The Virginia standard for E. coli in freshwater is 235 colony forming units per 100 milliliters of water. And so I like to encourage my fellow farmers that the biosecurity program on our farm is only as good as the worst farm upstream. And I can tell you as a farmer that over 50% of the cattle diseases in the mid-Atlantic states are transmitted through the fecal oral pathway. And so diseases like leptospirosis, crypto, salmonella, and many others are, they're transferred through the water. Now, this is our farm in 2004 when we just planted the trees. We planted bare root hardwood seedlings. And 15 years later, this is what it looks like. And you can see the trunks of these trees. Many of them are 8 inches in diameter. So this particular riparian buffer on our farm is functioning properly. The roots, of course, help stabilize the soil. The leaves fall into the water and provide the foundation of the food chain for the aquatic ecosystem. And remember, when we fence the cattle out of streams, we have to provide the livestock with another source of water. This is just a picture of a gravity feed watering system that I helped put in. This is a pressure system. So we need to, develop a spring or a well, or put in a in-stream pumping plant. We can also have limited access into streams in those circumstances where the other two don't work. And we also have cost share funding available for all these water development systems. And we can put in a dry crossing that you see in the lower left, where we put a culvert in the waterway so that the livestock aren't ever in the stream. And this is a shot that we took of one of the banks on our farm where we had, Jeannie and I sprigged the bank with some, what we call live stakes, or, live willow twigs. And several years later, this is what it looks like. This is what it looks like today. Now, this is a very important point that I want to bring out. I get the question a lot, well, why do we want to plant trees along the banks of the water? Well, this is why. Improved stream health due to a forest buffer can increase the level of in-stream processing of nutrients and organic matter up to 8-fold. So if we can offer assistance to fence cattle out and then plant trees, we're going to get 8 times the cleansing power if we plant the trees. So I just want to reiterate a couple of points. One is, states need to have a financial and technical assistance program to help farmers do what's right for the land. And, society as a whole benefits a whole lot when we have good land use, and agricultural land is the best value for public dollars to treat. And I'm also a little bit in bewilderment that Pennsylvania has a regulation that prohibits the Commonwealth from enforcing a confined feeding operation from fencing cattle out of a stream. I've never heard of anything like that. So I'd like to see Pennsylvania have a cost share program. I think they have a bill going through their General Assembly process, but and hopefully that will come through. We've had one since 1984 in Virginia, and it's done very well. So that is the end of my presentation. So Sarah and John, if y'all want to open it up to questions, that's perfectly fine with me. Thank you very much for allowing me this opportunity.
Thank you, Bobby. Thanks for explaining all of the efforts that you have made on your farm to try to reduce those impacts. Seems like you've really gone above and beyond, and that was helpful. Do we have questions for our panelists? Anyone want to type a question in the chat? I mean, I will kick things off. I think the question probably on a few of our minds is based on the news we got over the weekend. John, what do you think impacts that will have on the litigation?
It's hard to say. We were talking to the lawyer for the Justice Department this morning. She wasn't certainly giving anything away at this point, and there's still a couple months left of lame duck session, and we're optimistic that lightning will strike twice, like it did for us back when we filed the lawsuit in 2009, there was a change in administration, and the new administration was very eager to try and resolve the litigation without appearing in court. And so if we're able to do that, that would be awesome. But right now, it's too early to tell.
I think we have a question from Joan. She says, Bobby, can you explain some more about that last point about Pennsylvania and fencing cattle out of streams? Well, now, my point is, and John, you can help me out, but, you know, for a confined animal feeding operation in Virginia, you cannot have you can't have a live stream in a feedlot that is a confined animal feeding operation. They're permitted operations. And I believe in Pennsylvania, they have a regulation that says they don't have to fence out a live stream in a CAFO. Is that right, John?
The statute isn't that specific about whether it's a CAFO or not. It says no administrative agency of the state or any political subdivision shall require a person to erect a fence along a stream in a pasture or other field for livestock to keep the livestock out of the stream. So
wow.
It's pretty broad.
So I guess Virginia's going to be pulling the weight for Pennsylvania, you know.
So we've got a question from Meha. She's interested in how groups that don't typically work together came together on this. Can you talk about that process and your experience with that?
Go ahead, Bobby.
Not understanding the question.
Oh, okay. I think what she's asking is how you know, we're aligned with like Anne Arundel County and Maryland Watermen's Association. You know, it's no secret that at times we don't agree on fisheries issues, for example. But it was pretty clear that we share a strong desire for good water quality in the bay, because we all recognize that the better the water quality, the more likely the fishery is to do well, and therefore so are Maryland watermen. Anne Arundel County has spent, I think it was close to $500,000 or more working to meet the WIP obligations that the state of Maryland has developed. And so it feels like all those municipalities upstream should be doing the same and carrying their weight. So it's a pretty much kind of an equity argument that, and they decided they would like to work with us because they understand the need for litigation in this case, because we weren't making any progress otherwise. The 2025 deadline is coming upon us, and we can't just all of a sudden wait like EPA would like us to do in 2025 and say, oh, gee, we missed it. So if you want to sue us, you can, and we won't tell you exactly when we might actually get around to meeting that deadline.
So let's see, Debbie wants to know what was supposed to be the enforcement of compliance and the accountability for Pennsylvania?
I'm not certain I'm following that question entirely, but you know, EPA sent several letters to the Bay jurisdictions in the development of the TMDL saying there will be consequences if the states and DC do not meet their obligations under the TMDL. And here's a list of 8, some of which are, you know, withdrawing grant funding. These are all things that are already tools that the agency has at its disposal under the Clean Water Act. It can take away point source permitting. It can assert what's called residual designation authority and say, you know, we've tried point source permitting for things in this particular stream or watershed, and we're not getting there. We've even worked with CAFOs, which are also permitted, and we're not meeting the goals. So we're going to identify other areas like just smaller animal feeding operations to be subject to TMDL limitations. and designate them as CAFOs and require them to have a permit and require them to meet nutrient management plans and reduction. So again, there are a number of alternatives that the agency has at its disposal to require compliance by the states. And really, that's all we're asking, is for the agency to take the whips back and to rewrite them so that they actually will attain the goals by 2025, which has been their agreement all along, and that the states and DC signed on to.
Thank you, John. Yeah, thanks for explaining some of those tools in EPA's toolbox. So we've got a question from a student. I'm glad we've got some students attending today. So Maddie wants to know, she says she was under the impression that the 2014 agreement was voluntary. Is the mandatory enforcement that the EPA should have been performing related to the 2010 TMDL? So a little bit of confusion about how a voluntary agreement became mandatory.
Sure. So the voluntary agreement was incorporated into Section 117G because 117G of the Clean Water Act says meet the goals of the Bay Agreements, including nutrient reduction and water quality attainment. And so by adopting the 2014 Bay Agreement, which incorporates the 2010 TMDL, you've now drawn it into the purview of the statute.
Thank you. All right, anybody else? Questions for John or Bobby? John, can you talk about what were some of the steps that were taken preceding the litigation? I know, CBF, and you lead up that charge. You do get involved with litigation, but it doesn't seem to be the first step that you take. You seem to take some steps to avoid getting into litigation if you can. Am I correct about that?
Yeah, absolutely. I mean, we've had members of the CBF staff participate with the Bay program, the Chesapeake Bay program, which is an arm of EPA and the states that have been working on TMDL implementation, and before that were the tributary strategies to try and get the Bay off the impaired waters list. And so through our participation in these work groups that are designed to attain the 2025 deadline, we've been insistent and submitted comments and participated orally in these meetings, saying you got to do more. You need to actually require Pennsylvania to meet the goals. They've said straightforwardly in their whip that they're not. And so it's your obligation, EPA, to do something about it. That's why we all joined together to sign on to these Bay agreements to begin with. That's kind of the way we see things working, and the steps we tried to make. I mean, we issued a notice of intent to sue letter back in May. Never heard anything from the agency. Wrote them another letter saying, the deadline is going to expire, and if you want to talk to us, we're here. And again, didn't hear anything, neither the states nor the Bay Foundation and the citizens groups.
Now, I think it's important to note also that we're not suing any farmers. We're suing the EPA for not doing their job. And part of their job is to carry out the what is in the TMDL, which is to enforce the TMDL. So we're asking EPA to do their job.
Yeah, so that leads me to Joanna's question. Was there a consideration given to suing Pennsylvania directly?
Well, it wasn't just Pennsylvania. New York is £1 million short as well. And, just from, I'm not going to give away, our litigation strategy and considerations, but I think one of the things people need to look at is, if states sue each other, that's going to take things directly to the Supreme Court. And we didn't see that was the right path to go forward at this point. Again, as Bobby said, the issue here is EPA doing its job, because we feel like It's worked in the past. When Pennsylvania didn't meet its WIP obligations in phase one, EPA took action. In phase two, EPA has taken action by installing what are called backstop allocations. So remember when I said what a TMDL is, point sources and non-point sources, a lot of that non-point source pollution is coming from agriculture. But trying to be certain about how much nitrogen, phosphorus, or sediment is being reduced by those best management practices Bobby spoke of and showed you pictures of. It's kind of hard to get, a numeric assessment of how much that's reducing. And so EPA said, well, Pennsylvania, you've put a lot of weight on doing a lot of work in agriculture, and you're not getting there. So we're going to transfer some of that load allocation now to point sources and make it tougher on point sources. We think that is pretty much unfair for the point sources, because that now makes ratepayers have to pay more for upgrading wastewater treatment plants, for example. But if that's what EPA chooses to do, it can do that. But again, we didn't see that here in phase three. We saw it before, but not now.
I'd like to add something. I want to tell a story. Sarah, I think you brought up the first question. Are we going to see any difference now that we have a new sheriff in town? And I can tell you that, there's a big difference in the EPA under Obama than the EPA under Trump. We have seen a consistent and severe erosion of environmental regulations under the Trump administration. When Obama was in office, field people from the EPA actually came to the Shenandoah Valley. I've never seen an EPA person go to a farm in my whole life. And they did so under the Obama administration. They sent a letter to farmers. The Farm Bureau went crazy, sending letters to the farmers telling us how to behave, let them on the farm, but don't volunteer any information, blah, blah, blah. It was a big deal. But I can tell you, the farms that they visited and found violations, all of us farmers knew there were violations, and we just, we all wondered, wonder how long it's going to take. So that was, pretty impressive. And then we see just the opposite now under the Trump administration.
Thank you, Bobby, for that. So we've got a question about nutrient trading. So it's according to Dick, Maryland is much less oriented toward trading than Virginia. Do we see a role for a program in Pennsylvania or New York in terms of nutrient trading to try to help reach Bay cleanup goals?
What do you think, Bobby?
Well, I'm not familiar with the trading programs in those states. I am familiar with the nutrient trading program in Virginia. It's very robust and it's very easy. If you take a annual crop field in Virginia and plant trees on it, and you register your phosphorus credits in the Shenandoah Valley, you can get $14,000 a pound per acre for doing that. And so in Virginia, it's a 1-for-2 trade. In other words, a point source trade. Well, let me back up. If a point source polluter wants to increase their discharge, or if they're in violation and want to buy the right to discharge more, they have to buy 2 pounds of credit from a non-point source, from a farmer. So, in theory, that sounds pretty good, and it's working. I don't think it's working. I don't think it's been advertised as much as it should, because it's a very attractive program. Did that make sense?
Yeah, well, and just to show, I mean, you spoke about this earlier. I mean, Pennsylvania doesn't even have the programs in place and the ability to take in money or make these changes that the other states have done in order to attain the goals. So that's the problem with their WIP. I mean, it's only going to get to 73% of their goal. If they can come up with ways to do it, and I think that's what we're asking for, is identify ways to do it and the funding to get there.
Thank you, John. Thank you, Bobby. I think we are at the end. While we're on nutrient trading, I'll give a shameless plug. If you haven't subscribed to the Maryland Risk Management Education blog and you're interested in these issues, I suggest you do that. We will be having a post later this week highlighting some new resources for Maryland's agricultural community to participate in nutrient trading. That was done this past summer in conjunction with the Hughes Center, one of our sponsors today. So keep an eye on that. Please join me in thanking our presenters. You guys gave us a lot of your time and I really appreciate it. I hope that the last two sessions today were an illustration of just how many dedicated folks it's going to take us to reach these big goals. We need zealous environmental advocates, zealous environmental legal advocates representing those organizations. We've got farmers who are really dedicated to this cause. We've got excellent folks at the regulatory agencies and folks representing our county government. So it's not an easy problem. And I thank everybody for joining us today to learn more. Yeah, please go ahead and re-enter your name and your voucher number for that continuing ed credit. You should be receiving an email with an evaluation of today's session. So please take a few minutes and complete that for us so we can continue to improve this event every year. My last shameless plug is for next Monday. So last but not least, we've got two great sessions next Monday, November 16th, starting out at 2 o'clock with Waters of the United States, from Obama to Trump, understanding the rule and how it impacts agriculture in the Mid-Atlantic. And then at 3 o'clock, developing topics in agriculture, environment, and food law. So those will be excellent sessions, and I encourage you to pencil those into your calendar and register if you haven't registered so far. So thanks, everybody. Thanks for joining us, and I hope everybody's has a nice, safe week.
Thank you very much. Bye.